Hi, I'm Steve Wigrizer, and welcome to another edition of The Leading Question. Today with me is attorney David Rasner, who is one of the preeminent lawyers in the field of matrimonial law and family law. David, welcome to the show.
Thank you, Steve.
David, I'd like for our viewers to know a little bit about your background. Where were you from? Where'd you go to school? That kind of thing.
Well, I'm proud to say that I'm a Philadelphia local. I grew up in Mount Airy, went to Central High School, attended Temple University, graduated Temple University, and went to graduate school. I have a master's degree in European history, and I've been here ever since.
And did I get it right when I said that you work in the area of matrimonial law and family law?
Well, I like to say to people sometimes it should be called anti-family law. It involves the whole gamut of what are issues with the family, starting with the easy ones such as passive adoption, but moving into divorce, child support, child custody, grandparent visitation, support, all kinds of things that affect the family.
There are some people who think that if you go to a therapist, you're going to need therapy. If you go to a surgeon, you're going to need surgery. If you come to see David Rasner at the law offices of Fox Rothschild here in Philadelphia or in the suburbs, are you going to need a divorce?
A therapist, a marriage counselor are really all professionals that really may come before me, although there are occasions in my practice where I have referred an ambivalent client who comes to me who thinks the marriage could be saved to a therapist. I work with therapists regularly, both as counselors and also as child custody therapists as well. So that, but people that do come to me are looking to be divorced.
How should an individual select a divorce lawyer? What should the process be?
Well, if someone is interested in pursuing a divorce, they should talk to other friends or family who have already been through a divorce, because I think word of mouth is probably the best way to get to a divorce lawyer. And one has to be, I think, selective. Depends on the jurisdiction where that divorce may take place. There are lawyers, obviously, in every county, in the 5-county area that practice matrimonial law. So that's one thing. Number two, they should find out what that lawyer is about. Whether that lawyer is a problem solver, or a litigator, or someone who's just so fiery that doesn't resolve cases and just lets the cases burn out of control. The practice is a very emotional one, and I always hope to deal with lawyers who are as constructive, I think, as I am in the process of trying to get the matter resolved.
So you would fall under the category of a problem solver.
Correct, but a good problem solver, as I think you all know in your practice, a good problem solver also has to be willing to go to court and try cases, because you have to carry that stick around to impress the other side that you're serious. If you can't resolve the matter constructively, then you have to be prepared to try the case.
Well, typically when a client comes to you, or a potential client, are they already separated?
Good question. Yes, and that raised the issue, what is separation in Pennsylvania? And given the economy today, it is not unusual for two people still living in the home to be separated. Separated in Pennsylvania means a cessation of all marital activities, no longer holding yourself out as husband and wife. The community knows that you're separated, and the community knows that you're going to be divorced, and that possibly you don't go to functions together. If you go to your child's friend's bar mitzvah or something of that nature, you may be sitting at separate tables. So the world has to know that you are separated.
Well, what is the significance of that? Is there such a thing as a legal separation?
There is no such thing as legal separation in Pennsylvania. In New Jersey, yes, there is a legal separation. In Pennsylvania, it is factual. And the significance of that is that marital property in Pennsylvania ceases to exist as of the date of separation. So that all the assets which come before separation are marital. And we'll talk about what marital property is in Pennsylvania. But assets which you acquire afterwards, which are not traceable to a marital asset previously is separate property. So therefore, I'll take the easy one, a pension. Husband has a 401k. That 401k is an asset through to the date of separation. It remains an asset through the date of divorce, but if the husband then puts additional funds into that pension post-separation, those funds are his.
If something is a marital asset, then that property is likely going to be split in some fashion between the spouses. Do I have that right?
That's correct. And Pennsylvania is what is called an equitable distribution state. It used to be a common law state. Now it's an equitable distribution state. And what that means is that all the assets acquired during the marriage are tallied up. The asset, the value, etc. A spreadsheet. And the court then decides equitably, based upon factors in the divorce code, how the assets should be divided. So it's quite possible that if it's a long marriage, or there are children, and the mother has custody of the children, she might get a disproportionate share of those marital assets.
All right, but before we get to a resolution of the property or the marital property, there first has to be a decree of divorce. Isn't that right? Or maybe I have it backwards.
You have it backwards.
Okay, so maybe you should explain that to me.
You file for divorce in Pennsylvania in the jurisdiction which is appropriate. And then if you can't resolve the issues, Pennsylvania is a no-fault state, which means that marital misconduct is not relevant in how one divides the assets of the marriage.
Right. So I'm used to thinking about no fault in terms of motor vehicle accidents, where you turn to your own insurance company and satisfy your medical expenses regardless of fault. What does a no-fault divorce mean?
What it means is that both parties may consent to the divorce. They have to be separated in Pennsylvania for at least a period of 90 days and both agree to be divorced, or they must be living separate and apart for 1 year. And then either party can then file to move the matter forward. Otherwise, it just sits on hold for that period of time.
All right, so just to make sure we're on the same page, if a married couple agree to a divorce, then they will become divorced in Pennsylvania.
Correct, but the court generally does not what's called bifurcate the divorce from the resolution of the economic issues.
Okay, but strictly speaking, a no-fault divorce means that you can achieve or get a divorce regardless of whether you or the other spouse did something wrong or was at fault. So it would seem that would leave two issues. And I guess I should go back for a moment. So is there such a thing as a contested divorce on the sole issue of divorce?
Infrequently, yes. Pennsylvania is both a no-fault jurisdiction, but the fault grounds for divorce have remained as well. That's part of the law.
Okay.
So that indignities or adultery, those are also grounds for divorce in Pennsylvania. But the courts really don't want to hear those facts or those issues. They much prefer moving forward with a no-fault divorce. And typically, if you proceed with a fault divorce, that's going to take possibly longer because you have to prove those grounds. Each jurisdiction has separate rules pertaining to how you prove them, whether you go to a judge, whether you go to a master, how that's heard. So typically, the no-fault period tolls quicker than the fault period of resolution.
So the process is speeded up.
Correct.
Well, I'm going to assume that for the most part, I'm sure there's exceptions, that if one spouse files for divorce, the sticking points will not be whether or not the couple should become divorced. Sticking points will involve the distribution of property and or custody of any children.
Correct.
And I assume obligations to the children, support obligations, schooling, which we can talk about. And I don't even know if there is alimony in Pennsylvania. We can talk about that as well. So let's address that in order so that that I can follow along. So it would seem to me that the next order of business we should talk about is the property. And you've educated us to understand that property that was acquired during the marriage is considered marital property. I'm assuming that excludes inheritance.
That's correct. However, if someone receives an inheritance in Pennsylvania,
Right.
although the principal may be excluded, the interest accumulation on that amount is not. So that if someone inherits $100,000 and then they're married for 10 years, and that's now $110,000 of value, that $10,000 increment is marital property, subject to being considered by the court in terms of how it's divided.
Now, my understanding, correct me if I'm wrong, in my field, in the personal injury field, my understanding is that the proceeds of a personal injury case are also considered to be marital property. Am I right about that?
Yes, you are right about that.
So there may be a misconception that many of our viewers have, and that is that whatever the assets are, that they're simply divided in half, and that's how marital property is distributed. It sounds like the concept of equitable distribution controls, and therefore it would be up to the judge ultimately as to how those assets are distributed.
Correct, and there are other factors that go into what is equitable. The length of the marriage, the ages of the parties, what the separate earnings of the parties may be, who has custody of the children, whether either party has greater expectancies than the other, who can create more capital assets in the future. So there are a lot of factors that go into how the assets generally in the marriage are divided. And every county, I might add, has a different procedure, so that in most counties, the first step in deciding how the assets are divided go to what are called masters. These are people who are court officials, lawyers, not judges, who hear these cases and decide and make recommendations to the court in terms of what should happen. And generally, although the court can hear it on exceptions and decide it for itself, I'm going to say that in a lot of cases, or most cases, the master's recommendations remain, still hold.
I see. Just so we have an eye on the ball in terms of time parameters, how long does it take to get a divorce?
Again, it varies from jurisdiction to jurisdiction. My average case is a 2-year case from start to finish. It can be longer or shorter depending upon the issues involved and the jurisdiction that's involved. As I'm fond of telling my clients, you may have issues of support, issues of custody, issues of divorce and division of assets. The train leaves the station at the same time, but the stops along the way on each of them are very different. So that support gets heard first, custody may get heard second, and division of assets may get heard third. And they may get before different judges, not necessarily all before the same judge. And again, it takes a period of time to get those matters decided. So for example, in Philadelphia County, if you file a custody petition in a case, you will not get a listing for at least 1 year to have that case heard.
So, okay, so let's start with support, because you said that's one of the early stops along the train ride. What do you mean by support? Support of whom?
The first support you have, well, there are various forms of support in Pennsylvania. So we'll talk about those forms of support that are pre-divorce support, usually. So we have spousal support to the dependent spouse, also known in Pennsylvania as alimony pendente lite, literally alimony or support pending the litigation. Okay. And you also have child support if there are minor children. And in Pennsylvania, a minor child is a child under the age of 18. Unlike New Jersey. New Jersey, I think child support goes to 21.
I see. All right, so let's break that down. So alimony, that's a term that most people have heard of. I'm assuming that means that the primary wage earner who has been providing finances and financial care for the other spouse can't stop that support just because there's an intention to file for divorce or there has been a filing, that must continue for some period of time. Is that about right?
Alimony, strictly alimony. Alimony is post-divorce support.
I see.
Pre-divorce support for a spouse in Pennsylvania is spousal support or alimony pendente lite, APL. And there are different measurements in how you determine that level of support. So that spousal support and APL in Pennsylvania, as they're governed by statute, are really mathematically determined. They're basically formulas that tell us percentages of income and how much one individual should pay to the other spouse. It's mathematical. Post-divorce support, which is alimony, by statute, is based upon needs. So it's not supposed to be mathematically determined.
Is there always a right to alimony?
There is a right to alimony, but alimony terminates by law upon remarriage or cohabitation.
Okay.
Or by agreement of the parties. But again, in the absence of agreement of the parties, it will terminate upon remarriage or cohabitation.
All right, so going back to the pre-divorce support, because I think this is important. So if a spouse is miserable in a relationship and has exhausted all possibilities of rehabilitating the relationship, counseling, what have you, and wants to end the relationship, but is concerned because that spouse is not the primary wage earner and is afraid that if he or she files, there's not going to be a way to support him or herself. It sounds like that would not be the case, that individual would still be entitled to support from this concept of pre-divorce support.
That's correct. Maybe not at the same level,
Right.
But would be entitled to some support, again, based upon the mathematical formulas that are in place. Also, difference between alimony, which is post-divorce support, and pre-divorce support, is that marital misconduct, and we're talking about fault and no fault.
Right.
Okay. APL in Pennsylvania is awarded regardless of fault, so that the offending party might have committed a fault in the marriage.
Right.
Okay, but still he or she is entitled to receive support. Okay, spousal support is a little different. If you file strictly for spousal support and you had committed adultery, then that would be a defense to the other party paying support. So in most situations, one files for APL. That's just an oddity in Pennsylvania law.
It sounds like another good reason that if somebody is contemplating divorce, that they should come see somebody like you sooner rather than later, so that they can get the lay of the land and the roadmap and know what the reasonable expectations are.
Correct. I think it's important for someone, when they're contemplating this, to really talk to a professional and get an understanding of what the law is about. It's not that easy, and especially when you're dealing with a highly emotionally charged situation. People were intimate. I used to tell a judge, I may have told you, a judge once asked me, who knew me, he said, "David, define your practice." My response was commercial litigation with a high emotional component.
And that's exactly because at the end of the day, if the parties or one spouse decides that they want a divorce, they're going to get a divorce. The issue is the division of property. And of course, the next issue which we need to talk about, and that is custody and child support. What can you tell us in a few minutes about that vast topic?
Child support is formulaic in Pennsylvania. There are guidelines which really say that if your net income per month, combined net income per month of both the husband and the wife, is $30,000 net or less per month, and that's about maybe 80 or 90% of our population, then you go to a chart, and it tells you for one child, two children, three children, what that person should pay in support. And if you're over $30,000, then it becomes another situation where you determine the other needs of the children and also the incomes of the parties and extrapolate from there. So that there are also issues of private school, medical expenses, who covers the kids on the medical care is important to know, and summer activities, tutoring, that kind of stuff. All of those expenses are paid in proportion to the party's net incomes. So that the husband makes 80% of the combined total, and the wife makes 20% of the combined total, or zero. Then husband will pay 80% or 100% of those additional expenses until the divorce is finalized, and maybe even beyond.
So, yeah, that was going to be my next question. So, I assume that the obligation of child support would continue beyond the divorce decree, would it not?
Yes, it does. And in Pennsylvania, that continues to age 18. Again, unlike Jersey, which is a 21-year-old situation. Also, unlike Jersey, there is no obligation in Pennsylvania for a parent to pay for college for a child.
I see.
No obligation. There's a case that goes back. It's called Milne versus Milne. I know because I was involved in that case. And that kind of set the legislature into another position saying, well, parents should have no obligations beyond 18 for college. So that college becomes an important element in discussions with the opposing side in terms of who's going to pay for it and how much. Can you send your child to a state college? Or if a child has the aptitude and wants to go to Harvard or Yale or some other place, that's an additional expense.
So we've talked a little bit about pre-divorce support. We've talked about alimony. We've talked a little bit about child support. So let's get to the issue that I suspect is the sticking point in many of the divorces that you're involved in, and that is how to distribute the property. And you've already mentioned equitable distribution. Is there anything else about that topic that our viewers should know?
It all depends on the nature of the case that you're dealing with. If you're dealing with a case that is where the assets of the parties are limited, and I mean limited by the sense of having a marital home, a pension, which is a 401k, and maybe some cash in the bank, then presumably, the children are young, and the mom is the primary custodian of the children, and we'll talk about custody again in a second, then mom's going to want to keep the house and have the kids stay there, at least through high school. And the court will then say, okay, if the house is worth X dollars, net, none of the mortgage, none of the obligations, and the marital estate is worth Y dollars, then mom, you keep the house, and dad, you keep the pension. They can set it off that way. There are ways to make sure the assets are distributed in an appropriate way. But sometimes you have a case where the debts exceed the assets. And those are always the hard ones because how do you divide the debt, especially when one party makes all the income and the other party makes less. So those cases are difficult. But I want to get back to one thing we talked about, touched on very briefly, is the issue of custody. And I just want to tell the viewers that custody has changed over the years. I've been at this practice for a very long period of time. I won't say how long. And when I began the practice, there was a tender years doctrine, which is still kind of out there a bit, which suggested that for young children, the mother should have the child, should be the primary parent of that child. That's not so today. Jurisdictions today are much more shared oriented. And I would say, so even if you go for as to suggest that in most jurisdictions, there is a presumption that shared custody is what should happen. So that means that dad should get children 50% of the time, and mom should get the children 50% of the time. And so that's very different than what it was when I started to practice law. And also in today's world, you have many more wives having jobs in the economy. And that's changed. That's changed not only the issue of custody of children, but also for support and alimony.
I see. A couple of quick questions. In a divorce where each party is represented, and I'm assuming that that's the case most of the time, who pays the legal fees?
In my practice, I expect the party that I'm representing pays me the fees. But always the issue of counsel fees is subject to discussion and negotiation. And so that I may say at times to the other side, in my cases, well, I want the husband to pay me the retainer, and then we'll see where we go. And if you can't resolve the issue of counsel fees, then counsel fees is always subject to the jurisdiction of the court. And the courts, I might say, are generally reluctant, at least initially, to issue counsel fees. And let me also share this one fact for you, is that in Philadelphia County has the most pro se litigants of any jurisdiction in Pennsylvania.
And pro se means?
Pro se means without a lawyer. So there are cases which I may have where I'm the lawyer for a client, but the other side is representing himself or herself. And that always presents its own difficulties in terms of how you communicate with the other side and how you present your case in court and how the judge also responds to a pro se litigant. But that's again, mostly true of just Philadelphia, although even in Montgomery County, which is where the bulk of my practice is, there are still some pro se litigants, but not as many.
Okay, we've heard this term prenuptial contract or agreement. And I know that there's another type of agreement, and that is after the marriage or antenuptial. What is a prenup?
A prenuptial agreement means that prior to the parties getting married, they agree on what should happen in the event they divorce. And again, over the years, my practice deals with a lot of prenuptial agreements, whereas my early years, that wasn't so common. It's become more common as we go along, especially in situations where either the husband or the wife, future husband or wife, have significant family assets that they already possess, or they have an interest in their parents' corporate structure or entities or businesses, or they believe that down the road, when their parents may die, they may receive a lot in inherited assets. So the prenuptial agreement would cover all of those things, as well as trying to limit equitable distribution or support or alimony. What you can't put into a prenuptial agreement is custody of the children. That's always open for the court to decide.
So a prenuptial agreement sounds like a form of pre-divorce planning, actually.
It is. In a sense, it is. Although I think that when I try to do prenuptial agreements, I try to limit them and not be overbroad, so that if my client comes to me and he or she is in a successful business with a family or whatever, I try to carve that out and leave the other issues of support and alimony and how we do out the other assets aside. But yes, it is a form of pre-divorce planning.
You know, we only have a little bit of time left, but I want to ask you about the ethics of the practice of divorce law.
Well, I believe that the lawyer must be honest to the tribunal, to the judge, and must be honest with the client.
I appreciate your coming on today, and again, it's been most informative. And to our viewers, thank you for tuning in, and we'll see you next time on The Leading Question.